Testing 1, 2, 3, test 1, 2, 3.
Red keep. May it please. My name is Siduri Beckman. I, along with my co-counsel Alex Lewis, represent petitioner Red Keep. I will be addressing issue 1, whether the plaintiffs carried their established federal jurisdiction. Mr. Lewis will be addressing the necessary exception to requirement. We'd like to reserve. This court explicitly 3 years ago in TransUnion that an inserted information about adverse effects does not satisfy and has never satisfied Article 3 In 2020, access to the website, he sought to log a meeting. Was the website compatible or not? As the Second and Tenth Circuits have held in Hardy versus West Point Realty and Lauver versus Burr, Aemon Targaryen must show that he has some use today beyond bringing. Your Honor, the 11th Circuit's ruling is a direct violation of precedent, and precisely because in Lauper versus Anne, the case that you are referring to, they concede in their majority that there is no common law analog for the stigmatic injury that Ms. Lauper alleges. In TransUnion, this court noted that concrete injuries must have some kind of common law analog. It's precisely what distinguished the two classes of plaintiffs at issue in TransUnion. If Your Honor is referring to Lauper versus Atchison Hotels, Ms. Lauper did file a number of lawsuits. The case that came up to Supreme Court last year, that case was dismissed for mootness. However, we would note that Justice Thomas did concur to say that there was no right to information in the text of the ADA, which does go to whether or not there is an information injury here. However, our primary contention is that there was no injury because there was no harm that occurred. This information, as noted,
part of the ADA is to get information. Why isn't it deprivation of also standing it have been true? It's just or in public citizen versus justice.
I'll take your question in two parts, Your Honor. So to address the first part about the purpose of the ADA, as outlined in Section 42 U.S.C. 12101, the purpose of the ADA is to put consumers on equal footing. However, Section 12182 says that consumers must have that access to goods and services. Because that access to goods and services was available to Aemon Targaryen through those phone lines, and as well as by visiting—
He wasn't able to see the phone number because it wasn't available to through his oral.
On the record, it notes that his screen reader software at page 2 is unable to read images or buttons related to the Make the Reservation portal. However, at footnote 3 on record, page 2, it notes that there are two specific disability support phone lines. In addition, Mr. Targaryen could have called 411, completely unrelated to the website, to get the main phone number.
Well, that doesn't put anybody on equal footing. You've got them going through multiple steps. But since you are very well informed about the record, just to clarify for me, were those phone opportunities available at the time that the family was actually booking the hotel?
At the top of page 3, the red key indicated that it was more efficient to go through the website. However, because they did not attempt to call or Aemon did not attempt to go on the website, we have no information about whether that would have created a difference in his consumer experience.
But I'm sorry, was there a phone representative available at the time that they would have booked, as they've asserted it in the complaint?
Yes, Your Honor, precisely because it notes that it was merely more efficient, not that it was unavailable.
So there actually was a representative who would have taken that call at the time that they booked. Am I correct?
That is not in their complaint, so that is not in their record because the record reflects what they've put in their complaint. But given the fact that the red key indicated it was merely more efficient, we do believe there would have been a phone representative available.
So let's get back to this point about the injury, because I find your position somewhat confusing. I'm sure you can clarify it for me. I understand as an independent study he had gone on and he discovered that he could not access, didn't have the right kind of available interface with his software. But that would then discourage him from actually booking, which is what he would have done later on. Why isn't that enough? Why does he have to learn? Why does he have to learn of the lack of access in the exact moment that he wants to access?
I believe that one circuit in the Ninth Circuit has held that current can count as a type of injury. However, this court has never held that. In addition, because that is not specifically alleged in the complaint, under the Rule 12b1 standard, even though the facts should be taken in the light most generous to the plaintiff, because the plaintiff did not put that specifically in his complaint, the court cannot read in those facts.
What would you need in the complaint? What is the reasonable inference that you say we cannot draw?
That he had actual knowledge that the website was not compatible and that
How can that be? He did an independent study.
that independent study happened the year before. That was not close enough in proximity, and he had not attempted that as a consumer. That's what distinguishes testers from consumers who have standing under the ADA. Testers can have standing.
But it is true the website was not updated for this kind of access.
The record does not.
Just saying he should assume that in 1 year it was repaired so that he could access it.
The record does not reflect whether the website was able to be accessed by the specific.
Okay, so let me give you the hypothetical. Let's assume that he knew 1 year later, that he didn't go on it himself, but he actually knew. And there's not a factual dispute about that. Would that be enough to get you the injury in fact? He knew, and he would have booked this for the family, but for the fact that he can't access it.
Potentially, Your Honor.
Why is it potential as opposed to yes, they would have standing under those circumstances?
It would go to the specificity and the plausibility of the complaint that they put forward and whether or not this court chose to adopt the Ninth Circuit's approach.
No, but it's my hypothetical.
Yes, Your Honor.
So then, under the facts as I've suggested them to you, you agree that in that case, they don't have to know about the access in the exact, or first learn about the lack of access in the moment that they wish to use it, correct?
Yes, Your Honor. At that moment, the consumer who had that actual knowledge, as alleged in the complaint, would have travel plans. And that's what the 2nd, the 5th, the 10th, and the D.C. circuits.
Well, yes, in my hypothetical, the person
Yes.
is actually trying to book. I'm not giving you a hypothetical about someone who is just looking through websites. It was a different hypothetical. I just wanted to
Yes.
address the temporal issue.
Yes, Your Honor.
So you agree. You don't necessarily have to have the knowledge of the access for the first time, right, when you're first aware of it, at the time that you wish to actually access the web.
Yes, Your Honor, but we would caution the court about lowering the pleading standings when it comes to bare informational injuries without these adverse effects.
Is it your position that tester unequivocally standing?
No, Your Honor.
So what are the limitations?
As noted by this court in FEC versus Cruz, testers can incur injuries voluntarily in order to procure standing. However, there has to be some deprivation of a concrete interest associated with the statutory right that leads to that standing. That is what qualifies as a concrete, particularized, and actual or imminent injury. What is?
We're at the most dismissed stage.
Yes, Your Honor.
Okay. Why shouldn't we further demonstrate very types of?
As noted in Lujan versus Defenders of Wildlife, the burden is on the plaintiff to establish each of the criteria of Article 3 standing, even before a statutory analysis, as noted in TransUnion. This is an independent inquiry that the court must take. Crucially, under City versus of Los Angeles versus Lyons, the plaintiff here has not put forth any intention to return, even if the plaintiff had established a past harm, as noted by Your Honor in 2023. Even if the court found that, the court could not rely on this past harm to grant Amon standing, because the only relief available to Amon is this type of injunctive relief. There's no monetary damages at issue here. Without that future impending injury, that real and immediate threat of future harm, this case cannot proceed. Even Ms. Laufer, who was found without standing in the 2nd, 5th, 10th, and DC circuits, had in her complaint a complex system of revisiting websites where she showed each individual court that she filed when she had.
Isn't it true here that family?
Yes, Your Honor, which does also go.
How is that meaningfully different? How is that meaningfully different from Loeffler?
That's meaningfully different because they have not alleged an intent to return. Houston versus Murad Supermarkets in the 11th.
Sorry. It seems it's about law. Actually, stronger offer.
Lauver had a better position in terms of how detailed her complaint was when it came to the issue of injunctive relief. What this court holds for Eamon Targaryen, just whether or not they find he is a consumer or a tester, on this bare of a pleading would lower the pleading standards across the board and therefore put meritorious ADA plaintiffs.
So what would he have had to include? What would they have had to include in that complaint to get just past the line of sufficiency?
As noted on record page 1, these are the facts as alleged in the complaint. Not a single line of this narrative includes any intention to return whatsoever.
So if they've used the magic words, "I intend to return," that would have done the trick for you.
No, Your Honor. In fact,
So what's the answer to Judge Rivera's question? What is it that they have to satisfy?
to clarify my response, there is no magic words associated with this intent to return. However, it must be understood in some capacity that there is that future imminent harm that Eamon Targaryen is alleging going to happen to him.
So the complaint is we were discriminated against because we couldn't access the website. Nevertheless, we were able to book. Then we went and we were discriminated against completely. But oh, by the way, we want to go back.
By the way, we want to go back is precisely what is missing from this complaint, Your Honor. And even if this court finds...
Where's the logic in that, please?
The logic in that...
Where's the logic in that?
The logic in that is injunctive relief is an equitable remedy that is only granted in circumstances that warrant it. Without a future harm, this court would invade on the legislative power and as well as the executive power in enforcing the law.
Can't we...
Your position imply that you also believe that the website is not a public accommodation?
Without Article 3 standing, one can assume there's an injury in law and still fail, the plaintiffs can still fail at this stage of the case. However, we would argue that a website is not a place of public accommodation, looking to the plain text of the statute, as well as the fact that it does not serve as any exclusive nexus point in the approach adopted by the Ninth Circuit or as an intangible barrier.
Why isn't it just a service of the public accommodation? Because that's covered. Why isn't the website a service, a means by which to book? And learn about the venue, learn about the public accommodation, perhaps be enticed to actually book.
Under the nexus test, the question is whether something is exclusive about the website, whether they're, as in Robles and Domino's Pizza, they're exclusive deals or something that distinguishes a consumer going to the website from a consumer going to the physical store. Similarly, in the...
No, I'm asking a different question. I appreciate what your argument is about the nexus. I'm putting the nexus aside. Saying, why isn't it a service provided by the public accommodation?
If Your Honor were
It's a means to book, and booking is a service.
It is not the only way to book, and therefore the goods and services are still available. So
the fact that you have multiple ways to book
yes,
makes
Your Honor.
any one of them a service? So none of those are a service?
Would you mind clarifying your question, Your Honor?
Well, I thought you were saying because there are other ways, right, to book, that then it can't be a service. Did I misunderstand you?
No, Your Honor. What I meant to say was
yes.
The fact that there are multiple ways to book allows Eamon to access the ultimate goods and services of the Red Keep, which is the hotel and the amusement park.
Counsel, I'd like to go back to following up on this line of question. I'd like to go back to something early on in your argument. That is that phone, availability of possible phone, places Eamon or placed Eamon, putting trying to make out. Now, I want to clarify that that is in fact that
I see that my time has expired. May I briefly respond? Thank you. Your Honor, I believe the record is unclear as to whether the phone numbers were unavailable precisely because it identifies those images and buttons as being incompatible with the screen reader technology. But we would also like to note that in the guidance promulgated by the DOJ, it offers as an acceptable alternative to website compatibility that Title III businesses have phone lines available for individuals with visual impairments.
Your position, to be clear, is that the denial of information alone is not sufficient.
If it is not explicitly provided for in the statute, as it was in Public Citizen and Akins. Thank you. We would ask this court to vacate remand with instructions to dismiss. Thank you.
May it please the court. My name is Alex Lewis, and I will be addressing the Red Keep's necessary, safety-based eligibility criteria. Red Keep forced safety criteria on 2 rides, the North and the Mountain and Vale. They did this to keep their riders safe. On the first ride, the North, as noted on record at page 4, ride inverts or flips upside down at 5-minute increments.
Something that why shouldn't we find that Red Keep failed to provide any reasonable accommodation to Eamon because there was no spoken text provided on the Isles and Rivers ride, made it less interesting for him than for other individuals?
Yes, Your Honor. There are 2 rides which are included in plaintiff's complaint but aren't covered by the cause of action they brought. Specifically, their cause of action is under Section 12182B2A Romanet 1 of the ADA, which deals exclusively and only with eligibility criteria. A claim of auxiliary aids, which is what would be required on that ride, needs to be brought under subsection 3, which is a distinct part of the ADA, because it wasn't properly pled in their complaint. They cannot now raise it here. This is the same.
What if they didn't mention any subsection for anything, but nevertheless described what they claim is the discrimination violation? Would that be enough?
No, Your Honor. In that hypothetical, there would be a separate issue, because if they don't make clear where their cause of action is arising from, then it's not clear what they exactly are pleading. And so that would be a separate issue.
They say the ADA, but they don't necessarily mention the Romanet.
Then, Your Honor, we would be in the world of determining under Rule 8, was it sufficiently and properly pled with sufficient specificity? And that would be highly dependent on the exact complaint. And unfortunately, we don't have the exact text of the complaint here. What we do have is a summary. But what we do know, because of the question presented to this court, the certified question on page 35, is we are dealing narrowly and exclusively with subsection 1. That means that, to answer Your Honor's point, there is also a question of the inaccessible path on the water park ride. That is covered under subsection 4, which deals with accessible paths, and so is also not an issue here. As noted on record at page 5 and record at page 4, there are only 2 rides with eligibility criteria at issue. That's the North and the Mountain and Vale.
Do you acknowledge that there is some tension between state law and federal law?
Your Honor, here the state law is entirely discretionary, and so it makes it fundamentally different from state laws that have been dealt with in lower courts, such as the 11th Circuit.
I get that, not my question. But is there any tension between this state law and the
No, Your Honor. This state law, which is Aaron State Law 1.101, as noted on record at page 9, attempts to provide greater protections for individuals with disabilities than does the ADA. It does this by beginning with a comprehensive protection for all individuals with natural
So is this an area? Is this an area where both state and federal legislatures have weighed in on?
Yes, Your Honor. However, importantly, the state legislature here, Aaron State Legislature, created a discretionary law. The Red Keep chose to enforce criteria not because they needed to under state law, but because it was necessary to keep their riders safe as allowable under federal law.
Since this is an area where both a state and a federal legislature weighed in, under the Supremacy Clause, why shouldn't the ADA basically trump all of the state law requirements that you're pointing to?
Your Honor, the federal law does trump all state law, and our defense relies exclusively on federal law. The 14th Circuit misinterpreted our defense in focusing on state law. They attempted to adhere closer to the analysis that was done by the 11th Circuit in Campbell. However, importantly and critically, the Florida law at issue in Campbell required the public accommodations follow the manufacturer guidelines given to them, while here the state law merely says they may implement
So
certain.
are you saying not one of your defenses?
The state law is not our defense here. We're not saying that this is necessary because the state told us to do it. That's not the meaning of necessary that we are raising. What we are saying is that necessary means safety criteria. We can see this both through the plain language of the ADA as well as the congressional record. And because under the plain language of the ADA, necessary eligibility criteria, even those criteria that tend to screen out individuals with disabilities, are still allowable. We can look.
Very inclusive. How are you?
Yes, Your Honor. We can do that through two ways. First, beginning with just the dictionary. The ADA was enacted in 1990. The 1990 Merriam-Webster Dictionary defines necessary as things needing to be had or done, and it uses as an example food being necessary for life. So just indicating a general connection between life, safety, necessary. Even more helpfully, though, we can look at the House record that accompanies the ADA. That's House Report 101-485. At page 58, Congress discusses what kind of safety criteria they believed would be allowable under the necessary exception that they created. One of those safety criteria that Congress specifically lists on page 58 is a height requirement on an amusement park ride. The exact same type of safety criteria the Red Keep imposed on the Mountain and Vale. Congress explicitly endorsed exactly this type of narrow and specifically targeted safety criteria.
Well, what about the requirement of having both?
Yes, Your Honor.
I mean, people get on rides and they let go.
Yes, Your Honor. And here, I want to note that we are on a motion to dismiss posture. That means it is this court's precedent of Ashcroft v. Iqbal and Bell-Atlantic v. Twombly that is going to control. In Iqbal, this court said that courts should apply their experience and common sense. And here, we can address that with the common sense of when a ride turns upside down, you need to be able to hang on. And we can unfortunately see how that plays out when people can't do that through Jamie's injury, which is in plaintiff's
But do
own.
you mandate that when the ride turns upside down, everyone must hold on?
Yes,
There
Your
are plenty of pictures available on the internet where people aren't holding on when the rides are turning upside down, aren't there?
Yes,
Some
Your
of
Honor.
them think that's the thrill.
Yes, Your Honor. And to address both of your questions, I'll start quickly here. Some people take on the dangerous thrill of doing certain things that aren't safe. That's unfortunate. But when a public accommodation is setting up the rules for how to keep people safe, one of the things is imposing what people should do. So to answer your question in turn, Your Honor, as noted on the record at page 13, which is the incident report, Jamie was specifically told that he couldn't get on the ride for his own safety because the eligibility.
But
But then
isn't
you're
the
imposing it-
question
I'm sorry.
then, isn't the question then whether or not, given that people let go, they might find that part of the thrill in this particular ride or an amusement park ride like this, that saying you've got to have both limbs isn't what's necessary for safety because it's ineffective. You'll need something else to be necessary to deal with the fact that people are going to let go.
Your Honor, here, if I understand your question properly, it's that because some people might break the rules, we have to have both this requirement and something else.
Well, it's not exactly. You're close, but not exactly there. I mean, I think my point with this is, can't their claim go forward and then the struggle or the dispute will be about whether or not it's actually necessary. If one assumes, yes, safety is a necessary component of, or a required component of necessity, this necessity under the ADA, and then it's just whether or not that was necessary.
Yes, Your Honor, and I want to touch on the claim going forward because that's important. Here, the workability of the rule that this court will fashion is very important. And I want to point to 3 district court cases that illustrate this clearly. There are 3.
Before we do that, I want to go back to your answer to my colleague's question. It seems to me that if many riders, in fact, use just one hand because it's a thrill or whatever, that that confirms that this is discrimination and not a necessity, because not all of those people certainly fall off or get injured, or you would be in not in a very good position. Aren't you decision excessively protective way. Poor people have only making.
No, Your Honor, and I want to clarify my earlier answer. We can see from the record that the Red Keep has extensive training for employees as well as posted signage, so I don't believe it is the case that many people are letting go or not following the rules. It's only that even if people were doing so, it still is necessary to be able to hang
But
on.
counsel, I think you're missing the point of my colleague's question. He seems to be focused on the pretty obvious point here, whether or not Red Keep has used the least method to provide safety and yet make this ride available to the disabled.
Yes, Your Honor. That important point that you raise of least invasive speaks directly to the potential workability or unworkability of a standard. And that goes to what occurred previously. In 2014, there were 3 district court cases. That's Castellon v. Universal, which is out of the Middle District of California, Maskey v. Six Flags, which is out of the District of New Jersey, and Bench v. Six Flags over Texas out of the Northern District of Texas. All 3 of these dealt with eligibility criteria, and all 3 of these arose in 2014 because just a few years earlier, a disabled veteran named Sergeant James Hackerman, who was missing his legs and one arm, went to a theme park in New Jersey, was unable to stay affixed in the ride, and tragically fell to his death. In response to that, theme parks, including the Red Keep, Six Flags, and Universal, began to enforce more stringent eligibility criteria, and the litigation ensued. Here, we have very, very narrowly and specifically targeted eligibility criteria. Jamie is allowed to...
But see, perhaps I'm not being clear. That's my point at this stage, excuse me, in the litigation. Whether or not it really is necessary can't be determined.
Your Honor, I believe it can be, and we can do it by looking at the connection between the risk present, the actual risk present, and the narrow criteria that respond to it. Jamie is allowed to ride 6 of the 7 rides at the Red Keep. The only one he can't ride is the one that is not safe for him to ride. The same with
In your
Tyrion.
opinion, that's the point. He might have an argument as to what would actually be the kind of safety protocol you could use for that ride that allows him to safely use it.
No, Your Honor. Unfortunately for Jamie, we know that it was in fact dangerous for him to get on that ride because he ignored the park employee that told him it was for his own safety that he couldn't, and he was hurt in the exact manner that these criteria attempt to stop. And
That's
more...
not at all clear on the record that also whether kind of options, belts, or other things like that used that would have made it possible. That hasn't been.
Your Honor, I'll respond to both of those points. First, on record at page 4, we can see that there is a shoulder and torso strap that's on the ride. That wasn't sufficient to keep him secured because as the ride turns upside down, you have to be able to keep both arms secured. So there is that device in place, and it's noted on record at page 4.
There is a device in place, but we don't know that it's the best or the only adequate one, the only possible. There could have been a second seatbelt.
Yes, Your Honor, and I'll address that question as well.
And if that exists, that's the point, that it might not, what you're doing, not be what satisfies what's necessary. There's something else that would be necessary to ensure.
Yes, Your Honor, and I see that my time is running low. I'll try to quickly address both of your questions. To your second point of we don't know why he was hurt, it's stated in plaintiff's own pleadings that as the riding increased in intensity, and this is their words, his single-hand grip became insufficient, and that is what caused his injury. So we do know that it's because he ignored the criteria and his single-arm grip was insufficient.
A single-hand grip may have strap that you provided. That's possible.
My time has expired. May I quickly answer? Your Honor, to address that, there is a very good reason Congress did not impose such a high burden on public accommodations, and it's because it would be unworkable to enforce such expensive and extensive litigation to say that what they did in applying broad criteria to every single person, the millions of people that visit our public accommodations.
So you're saying, is that what you're saying?
No, Your Honor. It means it's unworkable to require that theme parks both be able to keep people like Jamie and Tyrion safe, as well as have easily applicable criteria that applies to the millions of people, and most importantly, that can be administered quickly.
Yeah, but what else you might do to ensure that he has access might very well protect those people who, again, for the thrill of it, let go with both hands.
Yeah,
Please,
thank you. Congress could have chosen, based on policy reasons, valid policy reasons, to instead adopt a framework much closer to subsection 2, which is a much more individualized inquiry and places a higher bar on public accommodations, but they didn't choose to do that. They recognized in subsection 1 that universal criteria are just more difficult to quickly administer. In Castellon, the lower court specifically noted that there is no valid cause of action in federal courts for claiming a design isn't inclusive enough. And that's because Congress never created one, because it would be too difficult and unworkable. This court shouldn't impose what Congress correctly chose not to include. That is a prerogative of Congress.
If the state mandated that, you have to install it?
No, Your Honor, because as Your Honor correctly noted, the Supremacy Clause means the ADA trumps. And the ADA says that valid safety criteria are allowable. If it was necessary to keep people safe, then yes, but it's only because the ADA would permit it, not because state law would permit it. For the reasons that we have discussed, it is important to ensure public accommodations can continue to keep Americans safe. And for this reason, this court should overrule the 14th Circuit and remand with instructions to dismiss. Thank you.
whenever you're ready.
Chief Justice, and may it please the court, my name is Pritham Chapada, and I'm here with my co-counsel, Henry Drembus, representing respondents. I will argue that Aemon Targaryen has Article 3 standing to challenge the Red Keep's website inaccessibility, and Henry will argue that the rider accessibility claim cannot be dismissed at the pleading stage. This case is about carrying forth the ADA's guarantee that no individual shall be discriminated against on the basis of their disability. The Red Keep is a massive amusement park with a hotel to match, but its website is non-functional to visually impaired users. The Targaryen family seeks to challenge the website's non-compliance with the ADA, but have been turned away at the courthouse doors on the theory that website testers lack Article 3 standing under the ADA.
So the Second Circuit that it's a person testing hotel booking site only as a tester lacks standing.
Your Honor, for two reasons. First, even if Aemon Targaryen is squarely a tester, he has an informational injury that this court has recognized. And second, because there are two other kinds of injury. There's a stigmatic injury and an imminent injury. There are three kinds of injury
Imminent?
here.
What's that?
Your Honor, the imminent injury here is that Aemon Targaryen's past actions establish an ongoing intent to return. And past actions can be sufficient to establish such intent. Here, opposing counsel points to the case of Lyons versus City of LA, but that case is readily distinguishable. It involved an individual claiming that there was an imminent risk that the LAPD would use a chokehold against him. That imminent risk could not be established. But in cases that involve a close nexus between the individual and the establishment, there is an ongoing imminence and intent to return.
I'm sorry, I'm having trouble understanding. I understand the stigmatic injury and the informational injury. I don't understand what the imminent injury is in this case.
Yes, in this case, Your Honor, the imminent injury is that Aemon Targaryen's past actions establish an ongoing intent to return. Page 2 of the record indicates he's visited the website. Page 3 of the record indicates he's visited the hotel and the amusement park. Page 1 of the record indicates he lives in the state of Erin, the exact same state that the amusement park is located.
Can I just ask you, if you're focusing on the likelihood or the probability of his return, if in fact there were no support for the idea he's going to return, he did not state that, let's say he explicitly said he doesn't intend to return, does that change your argument? Would you still say that they're standing?
Your Honor, it would change our argument. We would not say they're standing under the imminence theory, but there would still be an informational injury and there would still be a stigmatic injury.
How can you claim an injury based on background? He's got residence, and I'll focus on the background. You can focus on the residence. He's got this background in computer science, and he was logging on to websites to check to evaluate their screen radar technology. Right, that's who he is. So why shouldn't we take that into account in evaluating whether or not there is an actual injury here?
Your Honor, Eamon Targaryen is not just a tester. The facts are taken at the time of the complaint. And at the time of the complaint, Eamon Targaryen had not only visited the website as part of the school project.
But he is a tester, right?
He's a tester as of the fall 2022 visit to the website. But as of summer 2023, when the Targaryen family actually books the trip, he's no longer squarely a tester. He's someone who has a close nexus.
He didn't go on the website at that point, correct?
Correct, Your Honor. And here petitioner suggests a very narrow test that in order to have standing, the individual must have the intention to make the booking at the exact moment that they visit the website. This, however, is an overly narrow interpretation of Article 3 standing. And to return to Your Honor's question about residence, residence is clearly a relevant point if we look back to Lujan. The hypotheticals that are provided by the majority opinion are that a farmer who lives in Maine would have standing to challenge a dam built in Maine, but an individual in Hawaii would not. And the concurrence,
if you choose the extremes, you're always going to get that answer. To say that because he lived in the state of Erin, that he was presumptively, I suppose in your words, he was not only presumptively, but he was likely to return to the website. I don't think those two things are logical.
Your Honor, the single fact of residence alone is not sufficient. But there are additional factors here, and the Southern District of New York and Banana Republic has indicated that this is a highly fact-intensive inquiry that looks at past visits, proximity of services to plaintiff's home, and plaintiff's occupation or demonstrated travel habits. And all of those counsel in favor. An individual who lives in Erin and hates amusement parks and has disclaimed any intent to ever visit an amusement park would not have standing.
At the end of the day, he was able to book a trip, right?
Yes, Your Honor, he was able to book a trip.
He did it over the phone, right?
No, Your Honor. His brother had to make the reservation instead of him.
So they attended. They went.
Correct, Your Honor.
Where's the injury?
So, Your Honor, there's still a stigmatic injury because Eamon Targaryen—
Stigmatic injury for someone who's been testing all of their life?
Your Honor, there's a stigmatic injury for an individual who wants to make a reservation on behalf of the family, recalls the bad experience, and has to rely on his younger brother to engage in modern day-to-day activities.
Those aren't the facts as of the time he initially encountered the website.
Correct, Your Honor, but they're the facts as of the time of the complaint, and that is the relevant legal question here. Page 2.
Is that quite accurate? Because at the time of it would be one thing if at the time when they actually planned to book the trip, he attempted to go on the website and was unable to and felt the frustration, humiliation, what have you. But that didn't happen at the time of booking. I mean, the time when he was testing was, I guess, a year prior, and so it just carries over?
Your Honor, an important point of clarification here is one on the facts, and that's the question of whether or not the website is accessible, whether or not these phone lines are available. And the facts taken in the light most favorable to the non-movement, the respondent, is that Eamon Targaryen has visited the website and realizes it is fully inaccessible to him, and that the only way that he can make a reservation is by relying on his younger brother. Even if the only time he visited it is earlier, the facts taken in light most favorable to the non-movement is that the website is still inaccessible. Eamon Targaryen knows that and is made to feel like a second-class citizen because he cannot engage in modern day-to-day activities.
But he made no effort, and he wasn't intending to make an effort to go beyond testing the website. And how is it that if he has no intent to go beyond that, why isn't his complaint just a generalized complaint that he's unsatisfied with the website, but he hasn't experienced an injury?
Your Honor, if this court were to adopt the approach that an individual who is so stigmatized that they might not have intention to visit the website again because it causes them feelings of frustration or humiliation, does not have standing, that would create an unworkable test where even zealous plaintiffs would not be able to bring suit.
Well, what about the person who either doesn't have a computer, doesn't have access, doesn't know how to use a computer, or simply chooses never to book anything on a website and always does it by phone or goes in person? Are they also stigmatized?
No, Your Honor,
Why not?
that individual would not be stigmatized because of the particularity requirement. The individual who is able to engage with the website in the way that they do in the modern day-to-day life would not face stigma. But Eamon Targaryen, who
What
is
if they have no idea about how to use a website and how to book? And they have to ask their, 18-year-old niece to explain it to them.
Your Honor, that would not be
Isn't
stigma.
that embarrassing? Isn't that stigmatizing?
Your Honor, it might be stigmatizing, but not within the protections of the ADA. It would not be stigmatizing in the sense that the individual is made to feel like a lesser citizen on the basis of their disability. However, Eamon Targaryen...
But why isn't the phone access enough?
Your Honor, the phone access is not enough for two factual reasons. And this comes first from page 2 of the record, which shows that the website was not programmed to allow text-to-speech conversion. And
the website provided phone numbers, right?
exactly, Your Honor.
Did he call the number from the website?
Your Honor, it's unclear, but it's unclear if he's even able to read the phone numbers that are listed on the website. And the facts that are taken in the light most favorable to the non-movement are that he cannot even read these phone numbers that are on the website. Additionally, page 3
Where is that in the record, that he is unable to read the phone numbers that are on the website?
Page 2 of the record indicates that the site is not programmed to allow text-to-speech conversion, and that the website is incompatible with all screen reader software. It is a reasonable inference that...
I don't read that as saying that he is personally unable to read the phone numbers on the website.
Well, Your Honor, the record says the website is incompatible with all screen reader software, and Eamon Targaryen requires the use of a screen reader to read a website. It is a reasonable inference that he would not be able to read these phone numbers on the website.
Well, he's got the name. He's got the name of the venue. Just pick up the phone, call information.
Correct, Your Honor, and that's where the second fact comes.
Or Google it.
That's where the second fact comes in here, and that's on page 3 of the record, which indicates that due to high demand that summer, the Red Keep placed a notice that it was unable to efficiently allow customers to place reservations on the phone. Again, taken in the light most favorable to the non-movements, that indicates that the Red Keep cannot point to the mere existence of these phone numbers as an easy out from the claim that the most common way of accessing the Red Keep was not available to individuals with disabilities.
Is it your position that the website is a public accommodation?
Yes, Your Honor. The text, purpose, and legislative history of the ADA indicate that the Red Keep's website is a public
Well, except the
accommodation.
text of the ADA also lists as public accommodations only places that are actual physical locations. There's nothing like a website on it. So if we just based our decision on the plain language of the statute, wouldn't we be barred from finding that a website is a public accommodation?
No, Your Honor. The text of the ADA is ambiguous, but respondents have a textual hook here.
Do you agree that the only examples it gives of public accommodations are physical places?
No, Your Honor. The examples are ambiguous with respect to whether they're physical places or not.
Can you tell me what example is ambiguous as to being a physical location?
Yes, Your Honor. 7F includes travel service or other service establishment. And in the 1990s, people could call AAA over phone or mail to make a reservation. And today, travel services are overwhelmingly provided without entering a physical office. And the language of the statute is really important here. Congress did not say office of a travel service, but in the exact same definition, it says insurance office and office.
Since we're on the subject of congressional language,
Yeah.
what about the reservation rule? Look at the rule on its face. It doesn't really contemplate private citizens being able to enforce the statutory requirements. And if you look at Justice Thomas's concurring opinion, he also says that this is something that should be left up to the administrative agencies. How does that bear on your claim here?
Your Honor, two responses. First is that our theory of the case does not rely on the reservation rule. This is distinguishable from the law for cases in that sense. If we relied on the reservation rule, there would not be standing because ultimately Aemon Targaryen and the family did make a reservation. Our theory of the case is that because the websites are a public accommodation, Aemon Targaryen suffers an injury because he's been denied access to that public accommodation. And the second response, Your Honor, is—
I know that you didn't rely upon the reservation rule, but doesn't the reservation rule indicate that Congress did not intend for private citizens to be patrolling the internet for compliance violations?
Your Honor, our textual hook here is 12188, which provides that both the Attorney General and private individuals have a right of action here, that private individuals can seek injunctive or declaratory relief. And this is consistent with principles of efficiency for major federal civil rights legislation. And
So to be clear, you're taking the position that both the Red Keep, the hotel, the living accommodations, and the amusement park, that's a public accommodation. Maybe they're two separate public accommodations. I don't know that it's relevant to my question, but perhaps. And that the website on its own is a public accommodation.
yes, Your Honor, and that is our position. And
But need not have a nexus to the Red Keep.
Your Honor, the nexus approach establishes that websites are public accommodations if they have a nexus to the physical establishment.
Are they public accommodations because they're interactive? Because you can book? Or it doesn't matter?
Here, the website is a public accommodation because it is a service establishment under 7F.
So why isn't it just a service? The public accommodation is Red Keep. Thank you. The Red Keep, but the website is a mere service provided, the service of booking. It's a manner, it's a way in which one books.
Your Honor, it's both. It is a service that establishes a claim under the reservation rule, as Your Honor pointed out, but it is also a public accommodation in of itself as the purpose and legislative history of the ADA Council. And
What's the accommodation component of the website? I mean, obviously, a physical location, we understand what's being accommodated. You're on the premises, you're accommodated. What's the component of the website that's doing the accommodation work of a public accommodation?
It's websites that provide services are accommodations under 7F. A website that provides exhibition or entertainment might be a public accommodation under 7C. And this makes sense with the legislative history. The congressional committee reports indicate that the ADA should keep pace with the rapidly changing technology of the times. And that's exactly why this is a public accommodation. In fact, the DOJ has explicitly taken the position that the ADA applies to the internet and web-based providers. In my final minute, I'd like—
Sorry, if I could just ask you, so what's an example of a website that, a service-providing website that wouldn't be one? Or maybe your view is that every website that provides a service that is intermediary for a sale, they're all accommodations, or where's the dividing line?
Your Honor, some websites would not be public accommodations, but those websites would not provide services. For example, a personal blog would not fall under any of the 12 enumerated categories of kinds of public accommodation, and as such would not be public accommodations in of themselves. But a website that falls under one of those 12 enumerated categories of kinds of public accommodation would be
Would
covered.
it be, just to narrow you in a little more, any website that involves either a service or a purchase, something where you're seeking something, so taking blogs out or entertainment websites, something where the viewer of that website is either purchasing something or scheduling something or buying something, are all of those in the category of an accommodation?
Your Honor, I see my time has expired. May I answer?
Let me finish, yes.
Your Honor, yes, we would take that broader position, but that broader position is not necessary. This court can adopt the nexus approach and find that only services that are connected to a physical retail establishment are public accommodations. Under that approach as well, the Red Keep website is a public accommodation. Thank you, Your Honors.
Madam Chief Justice, and may it please the court, my name is Henry Drembus, and I also represent the respondents, the Targaryen family in this case. This court stated in PGA Tour versus Martin that the ADA provides a clear and comprehensive national mandate to integrate disabled individuals into the social and economic mainstream of American life.
But they still have to be kept safe, correct?
Correct, Your Honor, and we don't dispute that. I would actually like to begin with 2 points on which we agree with the petitioners. The first is that safety falls under the definition of necessary in section 12182B2A1 in the ADA. And second, that the state law here does not fall under the term necessary. And again, the Targaryens agree that safety is necessary, but here they simply ask the petitioner to comply with the ADA and show that their discriminatory eligibility criteria are based on actual risk, not speculation, stereotype, or generalization. Because we are at the 12B6 stage, there is simply not enough in the record for the petitioner to establish that actual risk.
So would you expect this would be remanded for discovery as to whether their criteria related on some realistic level to safety?
Yes, Your Honor, that's exactly what we would request. And that is exactly what the district court, or rather, excuse me, the 14th Circuit allowed in their opinion. And I also want to point out, opposing counsel discussed a lot of the definition of necessary. That is admittedly a legal question, but on footnote 10 of the record, this court was very clear that the question is not just what the definition of necessary is, the question is whether the Red Keeps eligibility criteria are necessary. That is a quintessentially factual inquiry that we cannot make at this stage in the litigation. I would also point out, similarly reminding the court of the procedural posture, all 3 of the district court cases opposing counsel cited, Castellan, Maskey, and Bench, were all decided at the summary judgment stage. None of those were decided at the motion to dismiss stage.
I mean, how much do we have to delve into the degree of the safety question? Because I think, you would agree at the front level that if someone is prohibited from being on a ride because of potential issues, certainly that's making them safer than if they got on the ride, if the person who didn't meet the height requirement, or, obviously I think your position is it's too broad, but if the requirement, the eligibility criteria do in fact, we can take at some level that they were making it safer for these members of the family, how do we decide, well, how safe is too safe? It's infringing on their rights to participate in this accommodation or this event.
So, Your Honor, under this court's precedent as far as the pleading standard for this kind of claim, the only thing to decide whether the particular eligibility criteria are discriminatory is simply, as the ADA says, whether they screen out or tend to screen out individuals with disabilities. And that is really not contested
right,
here.
But you said that you agree that in terms of saying that safety necessary includes safety. We can accept that if we're saying necessary criteria, if it's otherwise necessary, then it doesn't violate. And you're saying that safety does fit within necessary. And so I think I was taking your argument to be that, well, part of what the issue is we don't know that these actions or these criteria that they have, in fact, sort of fit the bill. And I guess I was saying that, look, we know that the criteria they imposed, or I'm saying we know that they at least make it somewhat safer, right? I think your argument, I assume, is that it's overbroad here, and so we can't rule at this stage because, in fact, maybe there are ways safety could be imposed with lesser requirements.
So, Your Honor, I would clarify the argument just a little bit and say that at this point, it is not a question of whether these eligibility criteria are overbroad, simply whether they are based on actual risk. And so it could be that they are, I would imagine that most height requirements are somewhat overbroad and that a person half an inch below the demarcation would probably be able to ride safely. And so we're not challenging whether an eligibility criterion could be too broad. The question is simply whether it screens out or tends to screen out an individual with a disability, as it does here. And at that point, the burden shifts to the petitioner to show that their eligibility criteria are necessary. That is clear from
Okay, so under your articulation, let's take the ride where you need both hands. Why isn't that obvious on its face?
So, Your Honor, I would definitely concede that Jamie's injury certainly makes it more likely that that two hands requirement was based on actual risk, but I would urge the court not to simply take the petitioner's word for it. For one thing, again, the DOJ regulation...
Why does anyone need to take their word for it? If you're hanging upside down, one would think that being able to hold on for dear life with both hands would be helpful to you, no?
Correct, Your Honor, that is true, but again, well, I would point actually to the Campbell case in the 11th Circuit. I think that's illustrative here, because in that case we had a similar two hands requirement, and it was for a water slide, and it was a very similar sort of risky situation. But after discovery, and only after discovery, the manufacturers of that roller coaster and the amusement park had to stipulate that their hazard analyses had shown no additional risk to anyone without two natural hands. So again, it could be true that here, just as a common sense matter, this two hands requirement is based on actual risk, but we just don't know at this stage. Also, Your Honors, I would point out with respect to that specific eligibility criterion, again, the DOJ regulations require that these are based on actual risk, not speculation or stereotype. The words based on, just as a temporal matter, seem to imply that the existence of that specific risk must be established before the discriminatory eligibility criterion can be lawfully imposed. So it does not allow for a sort of post hoc justification based on a single injury. Again, that we would agree certainly makes it more likely that the eligibility criterion is based on just on actual risk, but we just don't know at this point. Furthermore, Your Honor, we don't have any sort of similar or any sort of comparable evidence for the Mountain and Vale with the 60-inch height requirement. Page 5 of the record is clear. This is a 60 inches, a 5-foot height requirement. All we know about that ride is that it is a roller coaster that zigs and zags and goes at 100 miles per hour. There is, and the petitioners have not explained any correlation between the speed or the nature of that roller coaster and the height requirement. Height requirements, again, generally are ubiquitous. We acknowledge that, and we are not against there being height requirements for specific rides. But I would point the court to Garton versus Intamin Amusement Rides. This was a District of New Jersey case from 2021. In that case, the court discussed a ride at Six Flags that went 128 miles per hour in 4 seconds and had a 54-inch height requirement. Tyrion would have been able to ride that one, but not this one. There may be a very good reason for that difference, but again, at the motion to dismiss stage, we just don't know.
Well, did it have any height requirement?
On which one?
In that case?
In that case, yes, it was a 54-inch height requirement, 6 inches less than the 60-inch height requirement here on page 5 of the record.
So under your framing, what, if anything, would they have to show to explain why they're going to go 6 inches lower? But the 6 inches in there for this ride is absolutely critical to ensure safety.
Your Honor, at the discovery stage, the petitioner would have to show what they most likely already have. It is common practice for amusement parks and roller coaster manufacturers to do rigorous testing to find the optimal height requirement or general eligibility criteria.
And would you be satisfied with a test by the manufacturer?
Yes, Your Honor. At that point, we would. But again, we just don't have that here. And that was also the case in the district court cases that my friends on the other side mentioned. We just did not have the manufacturer testing or the amusement parks testing or anything like that, any mechanical engineering experts to show that they were necessary.
But I assume your position is actually going to be, once they do that, you'll just get your experts and say they're wrong. And it boils down to a battle of the experts.
Your Honor, I can't speculate as to our future strategy. I would say...
Well, I would hope that's your strategy, but all right, don't speculate about it. It's fine with me.
Again, Your Honor, If it is conclusive
Yes.
that these
Yes.
are necessary
Yes.
for safety, then we would have to concede that they are lawful under the ADA. But again,
But you're not conceding that you might actually challenge whatever expert position they put forward.
no, Your Honor, we would not concede that, not at this point.
I ask that because then I assume this is in line with your argument that it might be appropriate at the summary judgment stage, perhaps, to resolve this question, but certainly not at this stage.
Correct, Your Honor. I'd also like to discuss briefly something that petitioner brought up about common sense. And Your Honor also alluded to the sort of common sense of, obviously, if you're going upside down, you might need to hold on to something.
Common sense isn't usually a standard in 12b6 motions, it seems to me.
Correct, Your Honor. We would absolutely agree with that. I believe my opposing counsel was simply referring to the requirement from Iqbal that the courts use their judicial experience and common sense to determine plausibility. However, the mechanics of high-speed roller coasters are just simply not subject to that sort of common sense. However, even things in lower court cases that seem almost more common sense have also still been subject to discovery. I would point the court to Bauer versus Muscular Dystrophy Association in the 10th Circuit. In that case, the MDA required that camp volunteers for a summer camp that they had be able to lift and care for the campers. Again, that seems common sense. It would seem necessary for campers to be able, or for volunteers rather, to be able to do that. But in that case, the 10th Circuit still required objective evidence that that had been determined to be necessary for safety.
What about the fact that the state law in state Arian,
Your Honor.
Actually permits amusement parks to prohibit people with missing limbs in participating on certain rides. How does that bear on the analysis here?
Your Honor, I think it shows that the state is justifiably concerned with the safety of the patrons here.
That makes common sense, right?
It does, absolutely. But I don't think it gives the Red Keep just license to impose any sort of two hands requirement, even if the ride had nothing to do or had no actual additional risk for those without two hands, just like the ride in Campbell, Your Honor.
What about the other ride, the ride that goes, 75 miles an hour or something?
100, I believe,
100
Your Honor.
miles an hour. And that one has a height restriction, right?
Correct, Your Honor.
And in your view, is that height restriction valid?
In my view, the height restriction may very well be valid, but we don't know right now. That's the whole point, is that at the 12v6 stage, we don't have any idea how the Red Keep came to that 60-inch height requirement, and that is exactly what it is their burden to show. Your Honors, if I may just briefly conclude. For these reasons, we ask the court to affirm the 14th Circuit's decision and allow this case to proceed to discovery. Thank you, Your Honors.
May it please the court. Turning to issue 1, our opposing counsel has incorrectly stated that if the plaintiffs are unable to make out their burden on injunctive relief, they would still have standing. Lyons is not distinguishable in this case. Lyons is the standard for every plaintiff who seeks injunctive relief. As noted by this court in Whitmore versus Arkansas in 1990, the same year that the ADA was passed, that injury must be, quote, certainly impending in order to qualify for injunctive relief. Opposing counsel also brought up an imminence injury. In order to establish standing, an injury in fact must be concrete, particularized, and actual or imminent. All three are required under Lujan versus Defenders of Wildlife. Turning to the second point, the standard that the plaintiff puts forth for motions to dismiss under 12b6 is entirely unworkable, because there is no scenario that the plaintiff has pointed out that would allow for this court to dismiss a suit under 12b6. And instead, every time a public accommodation would have to engage in an extensive battle of the experts, as Your Honor noted, that cannot possibly be the outcome that is dictated by Ashcroft versus Iqbal, which instead—
Sorry, I don't understand. You're saying that if the complaint is adequate on its face, that it would be improper for the court to deny a motion to dismiss and permit the case to go to discovery?
No, Your Honor. What we've said is that the standard that the plaintiffs have put forth is unworkable because they've not left any option for any scenario to succeed under a motion to dismiss.
I'm confused because I thought that the second speaker specifically spoke about the importance of having discovery on these issues.
Yes, Your Honor, but in order for motions to dismiss to be viable under the federal rules of civil procedure, they must have an ability to succeed. The standard put forth doesn't allow the Red Keep, who has identified one risk. I see my time is completed. May I briefly answer Your Honor's question? The Red Keep has identified one risk on one ride for each of these two eligibility criteria at issue here. That does fall within that plausible common sense standard as put forth by Ashcroft v. Iqbal.
I'm a little unclear. I know your time is up. I'm a little unclear. I thought what he was arguing is that there's a factual dispute because otherwise there's a viable cause of action. But, right, that this factual dispute about whether or not the feature you've come up with actually indeed correlates with the risk.
Yes, Your Honor. However, the plaintiffs have not met their burden in this case to show that there is that factual question here with these two rides, precisely because they are so narrowly tailored.
So what would they have had to have done? Would they have had to assert in the complaint, this is their safety feature, this is their eligibility criteria, but they could have done this, because he just gave an example of that 6-inch differential. Obviously, it's good for some other park, and a court has upheld that. Would that be enough? Or even if they had just cited that case, would that have been enough?
Your Honor, we would first note that Congress explicitly identified in House Report 485 that a height differential is precisely the kind of safety requirement contemplated by Congress for subsection 1. In addition, they put out an example of the kind of safety requirement that—
No, but the point, he said he conceded that a height requirement might very well be necessary. The question is whether or not the height requirement you've imposed is necessary.
Because there is that—
And if at least one other court in another state or another amusement park is using a different height differential is fine, why can't they move forward then?
Because they've not shown why it would not be plausibly connected to safety to have this height requirement for a ride that has these specific risks of going as fast as it does.
Why isn't it your burden, once they've shown that indeed at least one other jurisdiction and at least another park have a different height differential?
For the case that they brought up, Campbell versus Universal Studios in the 11th Circuit, that is distinguishable from the case at hand, precisely because in that case, there was a state law that required the park impose a requirement on all of its rides across the board.
Yeah, but I don't know that really matters because it's the federal statute and it's either necessary or it's not.
Yes, Your Honor, our contention is that they have not met the burden here to establish that it is not necessary given the specificity of the risk to ride ratio. Okay. Thank you. For these reasons, we ask this court to reverse.
Thank you to all counsel. We'll take the case under advisement.
Get an action shot. Tillman.
All big. Smile. Good. You got your hand up. That stays.
That is. Oh, yes! So cute. And then you get in. Like. So cute. I'll send these all to you right now. Yeah, you can go up on the dais. Okay.
Yeah, let's just do this. Do we want to lower it? Oh, yeah, let's do that.
I think that they had it. Oh, it does go down more.
Is it going down even more? Don't break anything.
Don't break anything. It's fine. We're going to stop touching it now.
Yeah, that's good.
No. Okay.
It's just on little hooks.
Not touching it. Not touching it. Okay. Wait, you gotta be in the middle. Hold on. We gotta. Oh my god. All right.